Give it Monday to be mentioned. What is the date?
20th August.
This is original, sir.
Original sir.
What is the day mistake?
No, only one of the appeal number is
Oh. Send it to the original site. Ask them to get it. The next day when the original list is there, it can be at the top to be mentioned.
May I permit to mention?
Please, yes.
Last week I have mentioned, my lord, on Monday, my lord, the matter is not taken up regarding Group D recruitment, my lord. Let a time be fixed, my lord.
What is the serial number now?
Serial number now on the 24th August, it was appeared as item number 50, 51, 67, 68, 69.
Monday, Tuesday it will come. Monday it will be there. Monday it will be there. If it was at 50, they will be taken up on Monday, Tuesday. So I think this week it will reach. You mentioned.
I will mention the matter.
Yes, yes. You are always free to mention. Anybody is free to mention. Whether we accept or not, that is for us.
Oblige.
Yes.
My lord, I am seeking leave to prefer this appeal against the order dated 13 July 2023.
You want to move without a certified copy?
Yes, my lord, the writ petition is still pending. Because obtaining certified copy is paid.
All right, give it. Give an undertaking that you will supply the certified copy. Yes.
Upon your lordship permission, I am mentioning my matter for extension of interim order. I have filed a CAN application for extension of my interim order, and it has been filed within time, my lord.
When it lapses?
It has been lapsed on 25th August. 25th August matter also came in the list, but due to paucity of time, matter could not be taken up, and I filed it on 24th, my CAN application.
The other side?
Already informed, my lord. This is the letter. I have informed him.
List it on Tuesday.
When, my lord?
It will come. 1st of September.
Much obliged.
Number 1.
Item 1, I'm for the petitioner, my lord. I'm praying for some time, my lord.
Why, sir?
My lord, I need some more time to prepare myself, my lord. Only I have informed Mr. Chaturvedi, my lord, senior friend. My lord, I informed Mr. Chaturvedi, my lord, senior friend.
Lord, only one thing, my lord, subject to being corrected. Kindly sees my lord's last order, which is at page 408. This is 22nd of July 2026. Lord, my lord granted my lord liberty to my learned friend's client to avail remedy, appropriate remedy. Now, that is an order passed by the tribunal after this date, which may be challenged before my lord. But in the prayer, I don't find that any such order is under challenge.
Oh, we have already passed an order. Why it has
My lord, because my lord, initially what has happened during pendency of this original application, my lord, I approached, since the tribunal was not functioning, I approached the honorable single bench. The honorable single bench dismissed the matter, citing that the writ petition before the single bench is not maintainable. So, my lord, accordingly, I preferred an intra-court appeal. My lord, during the pendency of the intra-court appeal, my lord, in a WPST matter, your lordship has held that during the when the cause of action arose, original application filed, and tribunal was in session of the matter. Thereafter, tribunal became non-functional. In that scenario, the only recourse available to the petitioner is to approach your lordship.
Yes.
Yes, well, approach your lordships. So, on that basis, my lord, we citing that judgment, my lord, your lordship has disposed of that appeal, granting us liberty in terms of that judgment, my lord. So, therefore, my lord, we have preferred this WPST. My lord, may kindly seize, your lordship has referred to that order in paragraph 1.
Oh. Oh, so the earlier writ petition, the earlier MAT was challenging the order of the land single judge.
Well,
so now a writ petition has been filed. Oh, then it is all right. Nothing wrong.
Ideally, after 22nd July 2026, when my lord passed the order, there should be an order which should be challenged before my lord. This is, my lord, with regard to challenging something of 2023. The tribunal application is pending.
Yes.
Any order, that next date, as my lord, it fell from my lord on the other day, that next date is fixed. Challenging that, he can
My
come.
lord, in my prayer of certiorari, prayer A, my lord, I have challenged an order of the tribunal dated 24 July 2025. That
Because
prayer has
this
been.
is,
What is your objection? We are unable to appreciate.
no, my lord, objection is only with regard to the fact that it is only under exceptional circumstances, and having regard to the fact that the tribunal is non-functional, that my lord are exercising, my lord, the high prerogative jurisdiction. Now, after my lord passed the order on the 22nd July 2026, my lord, granting the petitioner to seek appropriate remedy, my lord, his remedy then again gets back to the tribunal, which is not functional.
No, no. Then you have not read our order. It is referring to, referring to 209, order passed in 209.
Yes, yes.
Yes,
Yes, Ananda Sunnu Das, my lord.
yes,
Yes, yes.
yes.
I may have misunderstood, but my lord, my small submission is that once my lord grants remedy, then the remedy lies in the tribunal. It is another thing that the tribunal is not functioning.
That is the first thing. That's not the another thing. There is no tribunal. Where he will go?
No, no, there is a tribunal.
There is no tribunal, sir. For want of a quorum, the tribunal is non-functional, so
Yes,
there is
Lord.
no tribunal in the eyes of law. It's a quorum non-judice. It cannot be. What they can do there? Nothing.
So now, date being fixed, my lord, in another matter, my lord, that is fell from my lord. My lord, I am only, my lord, trying to understand things. As in, my lord was of the view that even an order fixing a date by the registrar, you annex that challenge come before this court, bringing the entire proceeding before this honorable court. What I am on is that after 22nd July 2026.
Why he is required to challenge something after the court's date? We said that you have to avail remedy in terms of that judgment. We didn't say that only hereafter if some order is passed you have to come.
No.
Where you are reading that into that order, we don't know.
No, my lord said that to take remedy in accordance with law.
Correct.
Now,
No, to take remedy in accordance with 209 order.
my lord,
Please read it. That's why we are repeatedly pointing out to you. We have referred to that judgment. The
yes,
single judge also has referred to the same thing
My
in
lord.
the third last paragraph. He has said that since the matter was pending prior to the tribunal becoming non-functional, you are required to go before the division bench. They challenged it here. We said that there is nothing wrong. He is correct. You are supposed to come here directly. Why you are challenging the order in a miscellaneous appeal? So we asked them to file a proper application. They have filed a proper application, WPCT.
as my lord, please. As my lord.
If the cause of action arose after the tribunal became non-functional, there was no pending original application. They would have to go before the single judge.
My lord.
If it is pending before the tribunal, the single judge cannot consider in
Cannot.
view of L. Chandra Kumar judge.
Yes, yes.
Therefore, in that we have passed that order.
Yes, yes.
Till it is surviving, we have to go by that.
No, no, my lord, Ananda Sundar Das is prevailing, and with deepest of respect, my lord, if I may say, my lord, that is, my lord, inuring to the benefit of, my lord, the litigants who are, my lord, otherwise, my lord, in a quandary.
Correct. So we had to find some way out.
But I had, my lord, one doubt, my lord, kindly excuse me, I raise it.
No, that's good. That's why we heard you. We wanted to know what is going on in your mind. But we don't think the chronology is obvious from the order passed by the single judge and our last order.
Yes, yes.
So therefore, when do you want it?
Next week, anyway, subject to what?
Next Friday, my lord.
As jointly prayed list on. Give the date.
I for the petitioner, my lord. This is the affidavit of service, my lord. This is totally mercy appeal, my lord, before your lordship, my lord, because my lord,
Under which jurisdiction we can bestow a mercy?
because my
Please tell us.
lord, it is a appointment in the died in hardness category, my lord. At the time of death of his father, my lord, he was a 13 years old, my lord. He was the ST community, my lord. My lord, kindly see the region order, my lord. Kindly see the region order, page, my lord. Page, my lord, 49, my lord. Page 49 is the region order, my lord. Against that, I filed an OA application that was also rejected, my lord. After, my lord, page 46, 47, and 48. The petitioner, the petitioner is directed to submit some document. Thereafter, committee was constituted, and my lord, inquiry was held, my lord. Thereafter, my lord, passed an order, page 49. Against that, tribunal application was filed. My lord, tribunal, my lord, rejected on my lord, 19 June 2025, my lord. Against that, this.
Where is the three-man committee report?
Yes, my lord. Kindly come to page 40, page, my lord, 47, my lord, the constitution, and my lord, 48, my lord. Inquiry report in respect of the page 48, my lord.
No, this is not the form. Hmm. There's no separate application. Application. But Amy. Yes. Just it's a list of acts with the petition page. Yes.
But in my view, no relief can be granted. Despite the fact that compassionate appointment is always compassionate. But here, I don't find any case.
He has made application in 15, sorry, 16, no, 18, in 2018. Hmm. Yes. If he had applied. No provision supports your claim. Yes, heard the learned advocate for the But they have considered the change.
And number three.
You are filing an affidavit.
Yes,
May I take your notes?
Yes. What is this affidavit for?
My lord, the affidavit, my lord, on last occasion, last order passed, my lords wanted to know the status of WPST 364 of 2011.
Why?
Because the prayer in that writ petition, my lord, was similar to the prayer contained in this one.
Same rate petitioner.
No, not same, my lord. The prayer is similar.
Hmm.
My lord, kindly, if my lord takes the affidavit, my lord, kindly comes to paragraph 3, my lord, paragraph 3A.
He is also a driver.
No, my lord, he's a ex-assistant sub-inspector of police.
Paragraph 3A.
Paragraph 3A. So, my lord, he preferred a writ petition in 1988, my lord, pursuant to which his pay was refixed by way of an order dated 1998, 12/10/1998. The copy of the order is annexed, my lord. Despite such refixation, my lord, kindly comes to paragraph C, my lord, next page. May I please, my lord, is reading.
We are reading.
My lord.
So this is arising out of the fourth proceeding.
Yes. This is arising out of OA of 2013, my lord.
This is the fourth proceeding.
Yes.
First is the CO 1570. Then there is OA 21 of 2006. Then OA 9051 of 2007.
Yes.
And then now 137 of 2013.
Yes. Now, out of this 137 2013, this writ petition has been preferred.
And now he is challenging something which he never challenged for so
For
many years.
15 years, my lord, it was not touched. He accepted the benefit arising out of that government order, my lord, as well.
So in the subsequent applications, he has suppressed the 98 order.
That I do not know.
Must be, because if he disclosed, then he would not be able to pursue the litigation. Let us see, we want to deal with this person. You place the material, whether he has resorted to willful and deliberate suppression of the 98 order, which he did not challenge. Because after the first order passed in the writ petition, the authorities passed the order that second pay protection will not give you once we have given it to you.
Yes.
Now, instead of challenging the order, he filed another way seeking the same relief.
Yes.
We are of the opinion that probably he would not have disclosed this fact, otherwise he could not pursue the litigation. Because otherwise the relief would be not maintainable unless he challenges the earlier order of rejection. How he can get a relief?
Pilot.
So bring on record those details. We'll see. We'll need to deal with this person. He's indulging in luxurious litigation. Repeated. Huh?
This is the last 2030.
Take down. Heard the learned advocate for the
Panel fourth.
My lord, item 4, my lord, Mr. Shudip Shudip Krishna Datta, my lord, is appearing for the respondents, my lord. My lord, his wife is indisposed and requires operation. If this matter could be
How much time?
next week, my lord, next week.
My lord, he has also informed me, my lord, I
Yes,
was objecting,
he was
but
informed.
our difficulties were on the 10th September. The personal appearance was fixed before the tribunal of the high official. My lord, prior to any day, my lord, maybe fixed.
8th.
Panel five.
Item number 5, my lord, I appear for the petitioner applicant, my lord. Can 30 we have filed.
For?
My lord, for getting the copy of the expert report, for publication of the copy of the expert report. But in the meantime, my lord, the single bench has already started hearing out the matter, and my lord, expert report has been given to us by way of an affidavit.
Now nothing remains.
At least in the application, my lord, nothing remains.
And in the appeal?
Appeal is disposed of. It was appeal of the board. Appeal of
The
the
application is what number?
application number 30, my lord.
30. There is no other pending application.
Other pending applications are there. Almost the prayers are same, but I am not appearing for those, my lord. I am only appearing for can 30.
So 29, 31, 32, 33, 34.
There were other applicants, my lord. They had their grievances. But almost, my lord, the single bench is already hearing out the matter. That's why I think in the
And what is the date of disposal of the present appeal?
it was way back, my lord. Just my lord, it was disposed of initially in uh,
23rd August?
23rd August. And
23rd August.
subsequently,
Oh,
another clarification has been filed by the board itself. That was also disposed of.
now nothing remains.
At least for the division bench, my lord, there is nothing remains.
Trustee,
So everything now will be considered by the single bench. That is
Yes,
the.
my lord. Yes, my lord.
So the single bench has already published the expert committee report, madam.
No, we will not go into anything.
can
You are appearing in which can?
appellant. I am for the appellant, led by Mr. Shannan.
So now it will all be considered by the single bench. The learned advocates.
of-
Panel six.
I am for the respondent.
sorry. And on last occasion, my learned senior friend has shown that they have imposed an punishment, my lord. 25% of pension will be reduced. My lord, this needs to be challenged in a fresh proceeding, my lord. Now, the only request is that, my lord, as per an instruction sheet, my lord, which was perhaps handed over to this honorable court, my lord, where they have mentioned that my gratuity is left unpaid. But if that could be released, because punishment is imposed where they have not taken any steps towards curtailment.
Gratuity has been released subsequently.
25th
Enter. Yes, one copy. 2 copies, sir. Can you see?
release, sir.
যাবি দেওয়া হয়ে গেছে পুরো পেয়ে গেছে হ্যাঁ হ্যাঁ ফুল লাস্ট পেজ খালি এটা তো লাস্ট পেজ অফ দি বাঞ্চ মানে মানে লাস্ট পেজ মানে can you see বাঞ্চ পেমেন্ট হয়ে গেছিল ভাই ওকে হ্যাঁ আছে অর্ডার
You want to look to
Also passed by the accounts department on.
May I have a copy, my lord? Is it possible?
On the last occasion, we have given the copy.
copy has been supplied to
On the last occasion, when the matter was taken up, we have
supplied the copy
entire bunch, this bunch we have given.
To take a copy.
Yes,
Take a copy.
I shall get a copy, my lord.
Wife filed an application.
My lord.
Reversal.
Sorry, my.
Wife of the petitioner filed any application for the reversal of the railway board.
I do not know, my lord. I do not know. My lord has dismissed the writ petition.
Yeah, with liberty, what?
Runner seven,
For the respondents, I'm led by
You
Mr.
want us to say disposed? Disposed.
Item number 7, my lord, I appear for the respondents. It is an appeal of the Union of India.
Your Lordship,
At the outset, we are informed.
My lord, 7 times.
Your Lordship, Mr. Kundelia is on his way. Your Lordship, we seek a short pass over him.
What is it arising out of?
Your Lordship, it arises out of a CAT order.
What is the issue?
The issue is, my lord, the questions were wrong and we have challenged it. Subsequently, pursuant to the decision of the Supreme Court, my lord, it went to the Railway Board for the experts. Those who are not there in the previous committee will determine. Now, all the questions were determined by the experts. There were wrong questions and subsequently consequential steps have to be taken as the Supreme Court said. Thereafter, my lord, we approached the CAT again for another round of litigation.
Why? When it was done in the light of Supreme Court order instead of contempt, why did you approach the CAT?
Lord, we have approached in the contempt. We have approached in the contempt, but the Supreme Court, my lord, directed that if the expert, they will first frame an expert body other than the experts, those who are there previously, and they will take appropriate decision. That was the order of the Supreme Court, and consequential steps that follow. We have filed a contempt in the meantime. During the contempt, the Union of India came up with an application that not only the questions those were challenged in those writ petition, we have reviewed all and we have found many other questions, those who were incorrect, and we have given the proper answer key. Then we approached the tribunal for giving us appointment, publication of the answer key, as well as the expert report. The tribunal has passed an order in our favor.
To give appointment?
Yes, my lord. Because if the consequential steps, because my lord, if we
the
get
questions are wrong, how you can be given appointment? That we are
my
missing.
answer key was wrong. Now I have attempted the correct answer. And thereafter, my lord, I have made right to information, long pending litigations after litigations. And ultimately, when we got the answer key in the year 2021, pursuant to the order passed by this Honorable High Court, we found that the key answers were wrong with the questions. That we challenged. There, my lord, experts were formed. And thereafter, it was found that yes, what was our grievance is correct.
No, but even if it was correct, we don't know. We have not seen the tribunal's order.
But it's just a gist.
Your Lordship, the Supreme Court had already only given a limited order giving benefit to one person. These people, that is why, could not get any relief from the Supreme Court order. They have only made a representation after the Supreme Court order stating that their their answer keys be re-evaluated. Right.
So you are
Well,
alleging that they are fence sitters.
Your
No,
Lordship,
my lord, we can't be
will
termed as fence sitters because, my lord, we
We
already
don't know. We don't. We said they are alleging. We have
they are
not.
alleging. They are alleging. They are alleging, my lord.
We'll consider it in the next week.
My lord, any day, your lordship.
The paper book been prepared?
No, Your Lordship.
There is a huge voluminous document that has been prepared by the Union of India. We have made a small compilation, my lord.
You
With
have
all,
given us.
no, we can hand it over, my lord. Shoykot diye daw. A
Lordship,
small compilation, my lord.
It has all the relevant documents.
Huh?
Our writ petition has all the relevant documents.
This
My
one?
lord, read petition is very huge. We have made it as
Very
very
convenient.
small. With all the orders of the Supreme Court, High Court.
We are asking you to hand over a copy of this to them also.
Yes,
Or
yes, yes.
they will get a copy of this.
Yes.
If there is anything missing which they want to rely upon, they will be at liberty to file a short compilation.
Yes, my lord. Yes. My lord.
So accordingly, with a view to its final disposal, full stop, the learned advocate for the eighteenth. This Friday.
My lord, I'm handing over them a copy of the compilation.
Yes. Give it.
Now only.
Is not directed to hand over, has handed over. Copy to.
Grateful.
Number 8.
I appear for the respondent number 10, that is the Pradhan of the concerned Gram Panchayat.
For the petition. Kindly sees the order dated July 15 to 2026 passed by this honorable court. That there was a direction, July 15, 2026. That one slaughterhouse was being carried on in disguise of a restaurant. Earlier, we approached this honorable court by filing a public interest litigation where, my lord, the order was passed that your lordship will find at page 73. Now.
Here, Kota.
For respondents 9 and 10.
I am appearing for the respondent number 10.
Well, 9 is the Pradhan,
No,
9 is the Panchayat and 10 is the Pradhan.
Well,
Now
the
let kindly see
Pradhan
the
has
next order passed by this
certainly
honorable
appearing,
court of
and
6th of
for the
August.
last occasion also she appeared.
Let kindly see the conduct. 6th of August. Let the local Pradhan and the local police station, they are hand in gloves with the private respondents.
যেটা ফার্স্ট পিটিশন অর্ডারটা হয়েছিল সেটা কোথায় আসতে
Report, any report has been filed?
No, now let kindly see page 73 once. That is the order passed in earlier public interest litigation, but that was also not complied with.
Well, on the last occasion, London additional government pleader appeared and he tendered a report. After holding inquiry in my presence, I was also invited there. I also submitted all the documents relating to the grant of trade license and other documents. My lord, I have also, my lord, brought a explanation why I could not appear before the honorable court. I have stated that due to the, at the relevant time, due to the ongoing election of assembly election of 2026, my lord, the staffs, concerned staffs were otherwise engaged. Therefore, the those orders are not placed before me. That is why, my lord, I could not, my lord, appear. My lord, I have stated, and I humbly submit before your lordship, that the panchayat on the application of the concerned, my lord, proprietor of the hotel issued trade license, no objection certificate to run the hotel, subject to compliance of other statutory requirement. My lord, thereafter, my lord, after receiving the notice from the concerned police station, I, my lord, asked the proprietor to show all the documents. He placed all these documents. Those are, my lord, here, my lord, I am placing before your lordship. He obtained, my lord, the fire license, pollution certificate, all these things. But we have not issued any certificate to operate slaughterhouse, to run the slaughterhouse, nor the panchayat authority has any power to issue slaughter license. And on inquiry, my lord, I found that no slaughtering operation is being conducted in the restaurant. My lord, the police authority, when conducted the inquiry, I submitted all those documents, including that my lord, no objection certificate, to the police authority, and accordingly they prepared their license, report.
So, but you have taken a decision in terms of the PIL order?
I did not, because, my lord, the last order, no, I have not, my lord. I humbly submit that I did not.
You are for the Gram Panchayat?
I am for Gram Panchayat, I am the Pradhan only.
Then why you are not taking a decision?
I should have taken, my lord, because of the last order directing this is directing the superintendent of police, my lord, to take a decision and to file a report. Probably, my lord, that is why he, my lord, through the officer in charge of the police station, conducted inquiry.
No, we are not
But
going to we are
was
not going to examine the issue. This is
But
for
I
you
was
to
like
examine.
that I should have, my lord.
Unless the restaurant is stopped functioning fully, well, they will not do anything.
Sir, we will not review the earlier order passed in the PIL. Be very conscious of that. We are not going to review that order. That order says for interim relief, everything you go there.
But we prayed for.
You
We paid for the relief.
They will take the action.
Nothing has been
This
done.
is my explanation and the report.
No question of any explanation. You
Kindly
are
see
here.
the photograph.
Who is respond number 9?
Already it is
This
part of the record.
Panchayat. And I am the Pradhan of that Panchayat.
Nothing, will not see anything.
Right,
beyond the
that is
record.
also a part of the record.
Nothing beyond the record.
Right, that is also a part of
We are not going to get into this restaurant, one restaurant, the High Court Division Bench will see whether it is functioning in accordance with the license or not. Let them pass a final order.
Well, your lordship kindly grant.
And why a second order is required when already there is an order of the court?
Yes. I should not say in that fashion, but because of
What is the date?
I should have complied.
What is
with
the date
order.
of that order?
Last order is 30th.
March 26. Wonderful.
March 26,
Lordship, kindly
thereafter
grant me, my lord.
15 July,
Then I'll
thereafter 6th
issue-
of August.
issue
And
notice
what
to
was the
him.
time fixed? 45 days.
45 days.
I have already issued notice to the proprietor of the hotel. My lord, I asked him to produce the documents for running the hotel. He produced all the documents. I have got all the documents, but I have not taken any decision formally. If your lordship kindly grants me, my lord, 1 week's time or 10 days time, my lord, I'll place before your lordship my decision.
Why should you place it before us? You
There is a chain of connivance.
Pass
There is
the
a
order.
chain of
I
connivance.
give notice to him. I'll
In between the police authority, in between the Gram Panchayat and the private respondents. And they are showing thumb to this honorable court.
আমার তো কপি আছে তো না এক্সপ্লেনেশনটা দাও দেখেন এইটা লাস্টটা কপি কেছিলাম My lord, may I hand up these documents to your lordship?
We are not going to get into this. We are very clear. We will not get into this, but you have to take a decision.
Right.
Once there is a direction.
But I'll take a decision after
Yes.
giving notice to
If
him.
there
And
was
after
no direction, then it would have been different.
I'll do it, my lord.
Already a coordinate bench has passed a direction, still you are sitting on it. It's 4 months.
Irrespective of order dated 30th September, my lord, I'll my lord, comply with your lordship's direction, earlier direction. I'll pass it, decision, I'll take a decision. And I'll say, my lord, communicate to the petitioner.
Even there is no report from the SP.
এই তোমার কি
Who is
statement?
for the state? Who is for your?
My lord, I'm appearing for the state.
Yes.
My lord, on the last date, when the hearing, the report was filed before the court
That
as per
was
the
not
direction.
accepted.
No, after that, another report was filed.
You will interject to everything they say. There is a way to appear and assist the court.
I am tendering up.
Yes.
Yes, my lord. My lord, a report was filed as per the direction of the court. I do not know if the report is before my lord. If required, will produce a report again.
If you don't know, who should know?
My lord, actually, it was submitted on the last day. My lord, I'll take instructions. The report has been affirmed and it has been
Report by respondent number 7.
by the superintendent of police.
On 20th August.
Yes.
What is the report? Where is it?
My lord. Report,
আমাদের কাছে copy দেন।
From where you are making this statement? You
No, my lord, it was affirmed. I was also there when it was affirmed. So the superintendent,
come with that report.
I will come with the report.
Not
my lord.
today.
We'll place the report.
Monday you place the report.
Yes.
If that report
But
takes care of
can it be taken on 8th of September? Well, next week I will not be available in town, my lord.
as prayed by learned advocate
the personal appearance of the petitioner, respondent number 10, that is the Pradhan. May kindly be dispensed with. She is my lord, Pradhan Singh Devi, my lord. She is a Panchayat Pradhan, my lord. Today also there is a government program. Leaving all those things, she has come to your lordship. Pradhan. She is here, my lord. She is here.
Last occasion was filed in the court.
আমাদের একটা কপি দিয়ে দাও না আগে আগে
Where is the original?
What does she have to say? What should be recorded on her behalf? Don't ask her to come.
My lord, she will take a decision in the meantime, before the next date. That decision will be communicated to the petitioner, and I will place that decision before lordship on the next date. And my lord,
Make a record in view of the What is this? Why these things are pending for 4 months, sir?
My lord, the report has already been filed. Report has already been filed, my lord.
Why report has to be submitted here? When there is a direction in the PIL to conclude the proceeding within 45 days?
That has been done, my lord.
Not done. Nothing is done. Find out. It is adjourned to 8 September. Ensure everything is complete. Yes.
Yes, my lord. There was a running slaughterhouse which was in question, my lord.
We don't know, don't make submissions like that. Neither his exercise is complete nor the superintendent's report is here. And everybody is making submission.
Report has already been filed before the, my lord, erstwhile bench, my lord. Has already been filed, my lord.
Don't know. We asked him, he says he's not sure. Find out. Come with it. And you have filed it without giving a copy.
My lord, already been served. My lord.
You don't know, sir, you find out.
My lord, I was there, my lord. That's why he said, my lord, it has already been filed, my lord.
You were there, you say it was filed. He says, I was there, it was
No,
affirmed.
my lord. My lord, it
So
was,
which one of you is,
Yes,
we
sir.
don't know.
My lord, before my learned friend has entered appearance in the matter, my lord was appearing for the petitioner while doing the matter.
I was appearing.
My lord, my lord who is in charge, who is in Chief Justice's bench, Honorable Justice Otharu Banerjee, my lord.
We don't know, it is adjourned to 8th. On that day you point out. In the meantime, you get the exercise completed. You must be having a copy of that report. Yes.
opposition দেওয়া হয়েছিল যেটা কোর্ট নেয়নি তারপরে আবার দেওয়া হয়েছে, কিন্তু সেটা
Why you have not given a copy to them?
একটা কপি দিয়ে
A copy দিয়েছে। My lord, we are giving it.
Give it to him. Yes.
another copy may be handed over to me also. A copy may be handed over to me also.
Affidavit is concerned, that was filed.
What is that date? Show us the affidavit.
Because the last, the matter of taken was, it was.
Give us copy of the affidavit. Give us a copy of the affidavit.
Affidavit copy. My lord,
Come on, 8, sort out everything. Forget it. Yes. Give him a copy if the affidavit is written.
May I also be served with a copy?
Yes. He says he has given you, he has given us, he has given everyone. Let's see. Come on, 8. Yes.
Item number 9.
Your Lordship, for item number 9, I am for the appellant. I have taken leave to file a supplementary affidavit. The supplementary affidavit is ready, Your Lordship, but I have suffered a fracture, Your Lordship. As such, I am not able to come to court. I was praying if the matter could be taken after 20 days or so, then I could come physically and file it in Army.
Ought to be filed so that if they have to file any reply or opposition, that can proceed in the meantime.
Your Lordship, then it may be kept on Monday, then my junior will carry it and file it, Your Lordship.
Just have them file it. The learned advocate for the Union of India.
Number 10.
I am for the petition. My lord, affidavit in opposition and reply all are complete, my lord.
What is complete?
The opposition and reply, my lord, complete, my lord. Matter ready for hearing, my lord. My lord, the husband of the petitioner are missing, my lord. They have not traced out, my lord.
7 years.
Yes, my already gone, my lord. My lord, they have submitted a report, my lord.
When
My
it,
lord, their
when
objection is that, my lord, their record, my lord, one lady name appeared as a wife. My lord,
when the 7 year was complete, sir, when the civil death took place, on which date?
Yes, yes. 2009, long ago.
9.
2002 is missing. 2009 report was submitted, my lord. My lord, kindly see, my lord, one document they have annexed in their opposition, my lord. They have, my lord.
2009, his claim for compassionate appointment is pending.
Yes.
But he has been missing since 2002.
Huh.
It was, this is not compassionate.
Not compassionate appointment, only pension, my lord.
Only pension.
But calls reveal the name of that person. A second person has come.
He is not a nominee.
No, he is a nominee. But kindly see, my lord, the document.
Before we see anything, please spell out the basic facts. Who are you? Wife, son?
Wife, my lord.
Wife.
Wife.
And you have applied for pension,
Yes,
family
ma'am.
pension.
Yes, my lord.
On the ground of a civil death having occurred in 2009. When did you make the application?
Application 2009, my lord. Kindly see, my lord.
Any order has been passed?
No.
And this is the first round of litigation.
Yes, my lord.
So when did you file the OA?
OA was filed, my lord. I annexed in supplementary, my lord. I filed this OA, last action as per your lordship direction, my lord. I filed a supplementary affidavit, my lord.
22. OA filed in 22.
Yes, ma'am. Opposition.
Do you have any offspring? Any son, daughter also?
My lord.
Huh?
Yes.
How many sons and daughters?
Six children.
There are two.
He has given a name of another nominee also in the records.
Yes, ma'am. Now kindly see the age of the nominee, my lord. Why?
Any offspring? Sir, please give us the facts. There is any offspring from this Sabita Rani also?
Yes.
How many children she has?
6, my lord. 6 children. Kalpana children.
Sir, 6 children you have. We are asking about Sabita Rani.
There nothing.
There is nothing.
Nothing. She is not claim anything, my lord. He is not traced out also.
She is not claiming also.
No, not claim.
Then what comes in the way? Get an indemnity and pay to him.
Yes, my lord. I give undertaking, my lord, to give the indemnity, my lord, or any undertaking, my lord.
Because she hasn't come, but the name doesn't.
She not claim anything, my lord. Or not traced
Where
out.
is your application?
Yes.
Yeah, anyway, she will have no claim.
Well, kindly come to the page 27, my lord.
The claim, who is the first wife, that is the claim. But she hasn't raised any claim, but we have to name that. That is what we find. All the name, from the earlier records. 1969 records, we find Jyotitarani. And Kalpana, she has the much later. But both are our records.
It's the first one. Which year?
98. So subsequent to that.
So she is subsequent.
Yes, this is not.
You are not the first wife.
Yes, I'm not. But
Yes. You are the first wife.
yes, man, I am the first time. Kindly see that.
Where you have said in the OA that you are the first wife.
I am the wife. I stated, man, I am the wife.
Sir, just now you said yes.
Man, kindly, man.
Where your client has said that she is the first. Where your client has said that she is the first wife.
15 years old lady is the wife, my lord.
Where your client has said that she is the first wife. Show from the OA.
I have not stated anything.
You have not stated. So don't say yes.
Claiming as a wife. I claiming as a
Your
wife.
nomination has come much later, around 1990.
Yes.
98.
69.
He is not claiming anything, my lord. Your lordship direct them to take a decision, my lord. They direct them to take a decision, my lord.
No decision has been taken.
No
Which
decision.
is your pending representation?
Yes, my lord.
We don't want to pass order for disposal of representation unnecessarily. We'll determine whatever has to, huh? Very well. Where is your representation?
The representation is that, my lord, the page, my lord, 27, my lord, and my lord also, my lord, thereafter, my lord, on another representation
Only
of
generating a new case, nothing else.
Bengali, my lord, and my lord, page 32, my lord. Page 32 is thereafter, my lord.
Please be kind to me. How I will read what is
Yes,
written
sorry,
in the
my lord.
reference?
I beg your apology, my lord.
Give a translated copy of this. On
Uh,
Monday?
Monday, my lord, yes.
Not today.
12 PM, item number 62.
My lord, I am appearing on behalf of appellant. My lord, I just point out the point which I raised earlier, my lord. First thing, my lord, my learned friend's client is the award staff. Therefore, he has done adequate remedy before the industrial tribunal. Second is he is approached before the honorable court belatedly because impugned order passed by the appellate authority in the year 2013. They have challenged the writ petition in 2018. My client has raised the point of delay before the single judge. Single judge did not deal with the same. Third, my point is the petitioner never said that he is not guilty of charge. He says the punishment is disproportionate one.
That's his only plea.
Yes.
Disproportionate.
Yes, and so far the bank employment is concerned, my lord, trust and credence are the paramount consideration. And number 5 is, my lord, scope of judicial review unless and until there is a purpose finding or, my lord, there is any violation of natural justice or procedural lapses in the course of, my lord, disciplinary proceeding, the very limited scope before the writ court to interfere with it.
There is a question of judicial review when it is confined to disproportionate punishment, then
all this point, my lord.
Very concise and to the point argument.
Very precise, my lord. But my lord, he possibly, my lord, by mistake, my lord, forgets, my lord, what was the query, my lord, fell from the court. The court only, my lord, is concerned with the question that if it is a dispute within the realm of Industrial Disputes Act, whether it is maintainable, my lord, in terms. To that, the court had specifically asked me this question and to prepare myself on this court. Number one.
Another thing, my lord, I'm pointed out, so far the settlement is concerned, rule 5 of the settlement, my lord, even if there is no loss, if there is a chance of likelihood of loss, my lord, we can proceed with the discipline.
And what is the allegation against him?
Allegation, he has changed the, my lord.
Oh, that one. Change the introduction.
He has not changed. He has not changed.
Introduction form.
Allegation is identified, my lord. The identification is a question. I will take your lordship.
Identified and subsequently it was changed.
Changed by a person, my lord. That is also a part of record. He has not placed it.
He has not verified in a proper manner.
My lord, the my lord
should be more.
The inquiry report about charge 96. For replied to disproportionate punishment. Charge sheet 60.
Before we proceed, just to refresh, what is the prayer in the writ petition?
At page 48. Page 48 of the paper. A writ of and or in the nature of mandamus do issue to set aside.
So everything from charge memo till order of the disciplinary authority, everything.
And the inquiry report is praying for setting aside of inquiry report.
See, once we grant the relief, rate for in C. To act in accordance with law, then nothing remains.
Now, my lord, he has taken, my lord, he has developed, my lord, after the court had made the specific inquiry, my lord, he said, my lord, there are other points, my lord, to place. I cannot prevent him from doing so, my lord, it is the court's decision.
So he has, broadly, he has outlined what his argument is, firstly regarding that maintainability of the matter before the High Court in view of the settlement, Shastri award, it was amenable to an industrial tribunal. Whether there is an absolute bar or rule of discretion, so that argument. Second is, he says that the only allegation you have made is of disproportionate.
Yes, Lord. That is, my lord, I will take your lordship to the reply also, my lord, to the charges, 60 and 62.
And then he says the jurisdiction of the writ court to look into such issues is very limited.
he has, my lord, omitted to say, my lord, the findings of the inquiry officer, which always strike the conscience of the court in absence of finding. How could, my lord, the next step, my lord, the next step is also, my lord, the premise of the inquiry report, my lord, that is also very important to the court all the time.
The inquiry report was against you.
No. Inquiry report stands in my favor in a way. It says, my lord, there is no intention. Number one. Number two, the corroboration of the other evidences. That is, my lord,
So therefore, up to the stage of inquiry report, you have no dispute.
No, the inquiry, my lord, I said that the inquiry on the honor said that I have no, there is, kindly see the inquiry report, page 96.
No, what the honorable single judge, what the honorable single judge held. We don't remember. We are just trying to
Single
refresh.
judge set aside the charge sheet, inquiry report, everything.
Yes.
And even if, my lord, for argument's sake, if I assume there is a defective inquiry, even then both the parties can lay evidence before the tribunal.
So should my lord, his passionate insistence on this, my lord, the tribunal matter, my lord, may I address, my lord, have the liberty to address your lordship on the first point, which, my lord, he is quite sure about, my lord, of his survival on this court, my lord. So, my lord, if I may address your lordship on this point, because I have said, my lord, that he has not mentioned Section 2S of the Industrial Disputes Act, which defines, my lord, the definition of a workman. The last proviso, my lord, the last part of this act, it says, my lord, that if a person or employee, my lord, who is in supervisory capacity and earns more than 10,000 rupees, my lord, he has been excluded. No Shastri award can, my lord, be allowed to stand to that extent, my lord, so far as the definition of workman 2S is concerned. 2S categorically defines supervisory. In my affidavit, I categorically said, my lord, what is the nature of job. Now, my lord, the second point is that the Shastri award, my lord, I am a person, my lord, who is, my lord, who was entrusted with the duties, my lord, to the assistant, my lord, my duties in a supervisory capacity. Also, my lord, it indicates that I was excluded from the zone of consideration so far as the workman part is concerned and the industrial disputes. I will also rely on the part, so my lord, the first is, I will go by the statute, fact comes plus. The definition of 2S, supervisory capacity, and what is my duty. Kindly see, my lord, my service governed under Joseph. At the first page, I have not, it is no photostat copy.
Now, before we proceed, again, we are asking you. As per the stand taken by you, are you aggrieved by the proceeding till the stage of inquiry report?
I said, my lord, when the inquiry officer himself says that I have no intention, what is the letter, my lord, kindly see? Just
page 90.
Finding, that is, my lord.
Page 96.
96.
Inquiry report.
It is evident, 97, my lord. It is evident from the documents, may I read from my lords, submitted by PO during inquiry as well as deposition made by PO and CSE. In this regard, Srinjanath Mukherjee is a petitioner before your lordship, lead petitioner, verified the modification of introducer name using his ID in the system in such and such entered by Sri Taposh Kumar Banerjee on 9/1/20. Milord, your lordship wanted us, Milord, to submit the type copy, Milord.
Type copy কোথায় করে এনেছি আর বোকা বোকা কথা বল
He was directed to submit, Milord,
yes,
because
well, this is a mail copy.
He is not giving weightage to the court's direction. What?
We have a type copy.
He is not giving due weightage to the court's direction. You have to.
আপনাকে কোর্টের ডাইরেকশনে শুনবেন না কি বলবো
I'm sorry.
কোনো মামলা কর ওইটা কি জজ
Next page, Milord.
করে দিয়েছি তাই
EOS assessment.
জজ যেটা বলছি সেগুলো
It is evident from the document submitted by the PO during inquiry as well as the deposition made by PO CSE in this regard that Srinjanath Mukherjee had verified the modification of introducer's name using his ID in the system in the account number such and such entered by Taposh Kumar Banerjee SWOB on 9/1/2013.
What does that mean? What does that mean? What that means?
Taposh entered by It is entered through my system and done by Taposh. I will take Taposh's deposition. Taposh, the punishment inflicted on
Or
Taposh.
does it mean that it was entered by Tapas and modified by you using your ID?
No, Millard, no, because it verified the modification of introducer name using his ID system in the account entered by Taposh.
You verified the modification of
Yes,
introducer's name
my part is the verification only.
using
Then
his
it-
ID in the system.
I did not cause any change.
So you have verified
Only
that the
verification.
data entered
Yes,
by this
yes,
gentleman.
Yes. Now, Millard, what is he said? Mr. Mukherjee stated in defense, that is my client, that he had verified the above data in good faith on Mr. Banerjee, to whom everybody in the branch was dependent, and he was no exception. From the above, I am of the view that Sri Mukherjee should have taken minimum caution at the time of verifying the above data, which he did not, and verify the same. However, all the evidences and deposition on record do not suggest any malafide intention on the part of the CSE, and the mistakes so committed in all likeliness is unintentional. There is no denying the fact that the transaction was verified Sri Mukherjee in a routine manner. As such, I am inclined to treat the allegation as proved. In view, I am inclined to state the charge level against as proved. Kindly seize the contradiction. Not reconcilable. As such, I am inclined to treat the allegation as such proved. In view of what has been, I am inclined to state charges against Sri Mukherjee as proved under doing any act prejudicial to the interest of the bank, or gross negligence or negligence involve the bank in serious loss in terms of such and such disciplinary act or the workman signed between the Indian Banks Association and the workmen unions on 10/4/2002, circulated by the bank, vide circular number such and such as amended. The report is being submitted with the copies of the management minutes. So, Millard, in the absence of any.
So what action was taken on this finding by the disciplinary authority?
Millard, the termination ultimately followed.
What action the disciplinary authority took on this finding?
Disciplinary,
He differed with the finding, he agreed with the finding.
Kindly seize Millard, the disciplinary authority order punishment. Agreed.
He agreed with
Sir Millard in substance agreed. And I filed an appeal. They said they neglected that part. The malafide part was, Millard, consciously neglected. This was never discussed. Page 100, Millard. Kindly seize. Kindly seize, Millard. 101, Millard. In the matter of charge sheet, such and such, Millard.
No, where is his communication of acceptance of the findings of the inquiry of? Where is the communication by the disciplinary authority inviting comments that I have agreed with the findings of the inquiry of?
Disciplinary authority, Millard, only Millard passed an order based reliant on this. There was no such, Millard, that this part was not conscious. That is why I said, there is a law, Millard, your lordship, Millard, knows better than me, that Millard, that this, when there is when the inquiry officer has
come to page 98, sir.
98. The inquiry officer in respect of the charge sheet.
What is that paragraph 4?
I concur with the findings. That the matter ends. And how the concurrence, Millard, kindly sees next page.
So therefore, this is what we are asking you to show us.
So
he has 3 options: to concur, to defer, or to direct for further.
Yes. Now, Millard, this concurrence subject to correction, Millard, whether I am correct in submitting, or whether it is a correct perception, Millard, or understanding. That is, when the gentleman said, Millard, the inquiry officer, while inquiring, Millard, into the charges, he said, Millard, there was the malafide intention. He recorded, Millard, that my reliance on Taposh, Millard, is no exception, because everybody under the branch, Millard, placed their reliance, Millard, to the colleagues, which is not unknown. Millard, your lordships, Millard, possibly, Millard, it is also not incorrect for me to say that the court always, Millard, evaluates, Millard, normal human conduct, either it is in workplace or, Millard, in family or outside, or in a society. Now, Millard, if that is so, Millard, the law, Millard, or not always logic but an experience, Millard, if that is the proposition, then, Millard, my reliance on Taposh, Millard, is no exception and not abnormal.
Where is
And
your,
the-
where is your reply to this communication of 27/9/13?
27/9. Millard, I only filed appeal against this order. I did not, Millard.
No, no, 27/9/13.
Oh, charge sheet reply.
Sir, page 98.
Page 98 is, Millard, that to.
See page 99.
Yes, 77/9/2013. And it says,
Page 99, paragraph.
I shall
7.
also give you a personal hearing at my office at such and such,
Yes.
such and such, as regards the nature of the proposed punishment. Please appear before me on the aforesaid date and give your submission on the
So
proposed
they ask
punishment.
you to give a show cause.
Yes.
A reply.
You are hereby to call by the punishment as proposed above. Kindly cease the proposed disciplinary.
So where is your reply to this?
Simply, we have not replied. We have not. Kindly cease, if your lordship will permit me, the inquiry officer in respect charge sheet had completed the inquiry. Then, Millard, I observed full opportunity.
You are not aggrieved by this show cause, accepting the finding and proposing a punishment.
No. I was not represented by any lawyer, by the defense assistant.
We are not asking you.
Yes, yes, but the fact remains I did not. If that is so, Millard,
No.
I prefer an appeal. Question here is,
How you can prefer an appeal?
Millard, I can, Millard, kindly cease. Appeal was entertained and the order was passed.
Sir, when opportunity of natural justice is given and you don't avail of the opportunity.
Millard, I cannot, Millard, travel beyond the records. I only state.
Therefore, we are saying this is a hard fact.
Millard, hard facts.
Yes.
They propose, kindly, Millard, is dismissed without notice.
Then
Proved, Sri Indranath
you
Mukherjee
have
is
nothing to
dismissed.
say, then what the disciplinary authority will do? What he will do, tell us.
No, Millard, question
Put
is.
yourself in the shoes of the disciplinary authority, that a perverse finding according to you was accepted by him. He issued a show cause that based on such perverse finding as per your perception, he proposes a punishment of dismissal. You choose not to say anything.
I said, Millard, this was never replied to by me. Question is the consequence. হ্যাঁ, তাই না, ঠিকই করেছে। কেন হবে না, বাজে কথা বলিস না। তারপরে দেখ, you want to submit, এটা কে লিখেছে? এটা কি অ্যাপেলেট অথরিটি? হিয়ারিং এ
I am very much shocked to know that proposed punishment requests you to.
না, Millard, 99টাকে আমি বলছি এটা শোনো।
This is the stand take. So this and various termination.
জমা দিন, যেটা জবাব জিজ্ঞেস করে সেটা বল।
Opportunity is not availed. Natural justice.
Final order.
Turn around.
এটার এগেনস্ট আমি কিছু বলেছি, আমি বলেছি আই এম শক। নিশ্চিত এটা ইন গুড ফেথ।
লিখিত দিয়েছি।
Aryan. Aryan. Aryan.
And 99, 100, when the hearing was commenced, Millard, the show cause, I said, Millard, I'm shocked. I did not commit anything. It's a mistake and I've done it good faith. So, Millard, it is virtually, Millard, a response. It is not a complete silence, Millard, on my part. There are two parts, Millard, the show cause. You appear in the hearing and submit a written statement. The one part is not there, the written, but the recording is there, Millard. It is not nothing on record. I did not maintain silence. I went there, I attended hearing that has been recorded. I categorically said when the same question was being asked, Millard, common disciplinary authority to submit anything on the proposed punishment. I said, my lord, as per the hearing, I am very much shocked to note this proposed punishment. I and request you to pardon me if for my mistake with good that has been done by me in good faith. All my previous record is unblemished. Common disciplinary authority to CSC, anything you want to submit in the matter. After this personal hearing given to Indranath, there are two parts of the show cause. One is, my lord, to written submission. I said, my lord, it is a mistake. I relied on him. So it is not a complete silence or, my lord, a conscious relinquishment of my personal right bestowed upon me. And number one. Number two, my lord, right to livelihood, my lord, it comes within the periphery of, my lord, the Article 19, my lord. Then it is a question, my lord, subject to correction. The state can make any law, my lord, to regulate and prohibit certain actions, my lord, flows from 19.1. If that is the law, my lord, subject to correction, my lord, that is not a waiver or estoppel in respect of fundamental rights guaranteed. Here, my lord, it is not a complete silence. Number one. I preferred an appeal, my lord, as within the framework of Shastri Award. I went there. Now, my lord, if that is so, my lord, subject to correction, whether I am correct in making this submission before the highest court of the state, my lord, with deepest humility and respect, my lord, that the inquiry officer report, the basis of the charge sheet, the subjective formation of opinion based on the materials of record, are the premises, my lord, on which, my lord, it stands, are all, my lord, inconsequent of reasoning for the simple reason when the inquiry officer that this is a normal human contact. It is happening in office. And Taposh's punishment inflicted upon Taposh, it clearly indicates in no uncertain terms there cannot be two paths. It says, my lord, Taposh is, my lord, a person, but with, my lord, to that person, my lord, the fault is attributed to Taposh. 181. What is there, my lord? May I read, my lord, for my lord? Yes, he was dismissed. 181. It was never placed before your lordships. And there was no criminal proceeding against me. Taposh was same charges.
Court ultimately.
How can the two charges, my lord?
The dismissal of Tapas has sustained.
Taposh? I don't know.
Taposh is also dismissed.
Taposh dismissed. Taposh dismissed. How can
Is
two
the writ
different?
also dismissed?
Yes.
He also dismissed.
Two different proceedings. There was no, there should be a common inquiry. This was not done. Kindly see allegation 2. From the system it was found that the
Where is Tapas finding in Tapas?
Taposh minute 182, 181. $181, my lord, it starts from page 181. My lord's got it? 181.
সেটা আমার থ্রু দিয়ে আমি সেটা ভেরিফাই করি মোবাইল নাম্বার চেঞ্জ করতে আমি সেটাকে ভেরিফাই করছি তারপরে তো একসঙ্গে নামটাকে চেঞ্জ করতে হবে
সেটা কোথায় বলেছে? হ্যাঁ? আলাদা পেজ সেটা আমি বলেছি কোথায়? So, my lord, now the 181, my lord, your lordship have seen, my lord. Allegation number 2. And my lord, now my explanation, my lord, that is, my lord, in the paper work written, যেটা reply যেটা করেছে। এখানে আমি এটা করলাম। My lord, I categorically stated, I read for my lord's kind consideration. I say, my lord, paragraph page 4. It is specifically denied that the petitioner committed to commission and or omission in respect of one account in the name of Global Construction, which was introduced by one Taposh Banerjee using the customer's ID number such and such. I state that from the very outset, the said account was not properly verified at all, and there existed various irregularities and or illegalities pertaining to the opening of the said account, as it transferred from the copy of the account opening form of the concerned account, that is one Global Construction, which were produced by the presenting officer on behalf of the bank in course of the disciplinary proceeding. The same are to the repetition and form part of annexure P6. It is pertinent to mention here that in the same account, the introducer's particulars were not complete. That is, the address and phone number of the introducer was not verified, nor was the signature of the verified. The trade license number of the said account, said to be that of a proprietorship, was not mentioned. The column, the identity in the collection of bills was not signed by the proprietor of the business. The original account opening form was replaced with another account opening form bearing introduction by Messrs. A's Construction, which was without the signature of the branch head. The said account, having been opened on 25 September 2012, was opened and running completely from the very list of the officer of the highest rank of the respondent bank in connivance with Taposh Banerjee. It is denied in the charge sheet, video letter such and such. The petitioner tried to shift his action and or omission to one Taposh Banerjee. I state that it is a fact that the said senior employee of the bank, namely Taposh Banerjee, in collusion with the other senior officers, were involved with the fraud that was committed against the bank. In this regard, a criminal charges framed and appropriate proceedings initiated. I, an honest employee, was framed and duped by the said Taposh, and was in fact made a victim of the fraud. No criminal case was made out against me. I had no in the name and that transfer some records. In this regard, I repeat and reiterate the statement made in paragraphs 4 to 13. I deny that the order passed by the disciplinary authority is proportionate to the misconduct committed by the petitioner, and that there is no violation of natural others in conducting the disciplinary proceeding, that there is no complaint in that score also. I submit by the time the said order of the appellate authority was passed, the fact of the fraud committed by Taposh had come to the limelight, and it was evident that I was made victim of the same, as the Taposh Banerjee had, for obvious consideration and malice-ridden motive, took advantage of me and masterminded the fraud, which could only be uncovered by the intervention of the police and CBI. As such, I was made a scapegoat for such fraudulent act and disproportionate punishment in the nature of dismissal from service without notice was imposed upon me. Such being the fact, the respondent authorities concerned should not have proceeded against me. An improper, perfunctory inquiry was conducted, which resulted in me being victimized. So, my lord, the question, the understanding of my learned esteemed friend that it was only confined to the disproportionate punishment. My affidavit in reply.
Page 144.
Page 140. It starts from 144. 45. And I read for my lord, page 4, that is 148. And my sub. Yes, authority I said. Yes, authority, my lord, page, that is page 62.
Everybody becomes wise.
No, my lord, page 62. Yes, yes. Everybody becomes wiser. Page 62, I said, my lord, fourth paragraph, the subject allegation have the following background. You will agree that I adapted the rules and procedure and practice of the branch regarding working system as prevailing at the branch. The current account global construction was opened on such and such date when I just joined the branch. The account was opened by Taposh Banerjee and it was authorized by Shitangshu Chaudhary, the C2 officer. At that time, he was the manager. It should be noted that current accounts can be opened only on introduction of another current account holder. Here, the account of global construction was introduced. I had account. I cannot be stating that the account was confirmed signed by the senior manager of the branch. In this fashion, the account was running. It is a matter of regret that the account of was not kept in senior manager's custody, which should have been important documents of the bank. The documents were kept in open cabinet without any lock, for which there was adequate scope to fulfill the fraudulent intention to defraud the bank. The introduction of the account in the original form was done by Taposh Banerjee, who had fraudulent intention. As the document was lying, change the form containing the instruction and replacing the same with another form containing the introduction of MS construction. So, my lord, the question is not his understanding, my lord, to the extent that I have only, it is not that. I completely deny not only that, I explain the situation. Number one. Number two, that inquiry officer's report, when there is a finding categorically, my lord, the authority was left with only option before coming to inflict the imposition of punishment, that if the charges, my lord, he said prove, before that he said, my reliance was not abnormal on Taposh, entire branch. এখানে জেরক্সে আছে কেন নেই তাহলে এটা কি আশ্চর্য কথা
ভুলের জায়গাটা জেরক্স
কোথায়
ভুলের জায়গাটা জেরক্স করে প্রোভাইডার এটা হচ্ছে এটা ডিসচার্জ প্রসিডিং এর পার্ট এটা অনেক আগে এটা পেজ 70 এটা 440
কতবার চাকরি করেছিল
থেকে
আমি কোথায় এইখানে কোথায় বাইরে আছে আমার এটা কোনটা আমারটা কোনটা নামিলাড কোথায় নামিলাড the service rule, my lord, I am sorry, my lord, I apologize at the outset, my lord, but I shall supply the photostat copy. that it says, my lord, in avoiding punishment by way of a disciplinary action, the authority concerned shall take into account the gravity of the misconduct, the previous record, if any, of the employee, and any other aggravating or extenuating circumstances that may exist. Where sufficiently extenuating circumstances exist, the misconduct may be condoned, and in such cases, the misconduct is of the gross type. He may be merely discharged with or without notice or payment of month in lieu of notice. So, my lord, there is an assessment of the disciplinary authority, my lord. I am sorry, it is marked, my lord. And, my lord, the finding of the inquiry officer, my lord, and the action taken thereupon by the no, I said, my lord, the where is the assessment? The Joshua Dekhan? No, my lord, all right. My lord, no, I said, my lord, at best it could have been, but that today, my lord, that chapter is contemporaneous tone is lost today. I only say, my lord, that no, my lord. No, my lord. I only say, my lord, 33 years I have, my lord, served the bank. Now, my lord, that is, my lord, one aspect. Second aspect, my lord, your lordships, so far as my understanding is concerned, very latest experience, my lord, while interacting your lordships in any matter, my lord, your lordships always, my lord, insisted on the findings. The findings, my lord, it is the most logical premise, my lord, which sends a message. Decision may be wrong, decision may be right, but, my lord, the reasoning and the decision.
Whether it discloses a possible perception or
Yes,
view
my
or
lord.
not, that is
Yes.
the only.
And, my lord, that is, my lord, why, my lord, that is why, that, my lord, there is a relationship or the friendship between, my lord, the reasoning and conclusion, and also, my lord, the rationality and choice. Now, my lord, rationality or choice is not only, my lord, confined to only, my lord, a purchase of goods or economic field. It is also applies to, my lord, in our field also, my lord, because that is why your lordship insisted. Why? There is a reason. Now, today the finding is that there is the malafide intention minus malafide ill-intended likely to cause to prejudice. My lord, this is an utopian conception painted with his own imagination. He cannot, my lord, by any stretch of imagination, can put something, my lord, which, my lord, I will not forget everything, my lord. No, kindly do not listen, my lord. Justice Rai, my lord. He will not say, my lord, anything good, my lord, for me. His lordship, my lord. No, no, my lord, no, no. My lord, only, my lord. I'm feeling nervous, my lord. When your lordship talks, my lord, to my lord, Justice Prasad, my lord, I lost all track, my lord. I lose, my lord. Kindly do not, my lord, allow us to survive. Now, my lord, so second part is, my lord, the finding.
So, see, if we have understood what you are trying to say, one is that the inquiry officer's findings are not sustainable.
Yes. And disciplinary committee's action, my lord,
There
is
is
also consequentially
there is
fails.
no relationship between the consideration and the finding.
I am deeply impressed. And based thereupon, my lord, the disciplinary authority
Disciplinary authority has also not added to that in any way.
nothing. And as a result whereof the with a metronomical regularity, my lord, the appellate authority has also only recorded. And
Second aspect is that the finding may be destructive when considered with mutually destructive when considered with the finding recorded in Tapas inquiry, where the liability for the same action has been fastened on him.
Exactly.
Here it has been fastened on you. There is no finding of collusion or there is no finding of a conspiracy because it says in good faith you have done it.
Yes. Bank was very much, I'm extremely grateful, my lord. And my lord, that is why, my lord, I was not
But you have not said anything about maintainability.
Well, yes, now I'm coming. My lord, I'm
You
extremely
are going in reverse
yes,
order.
yes. My lord, ধারাটা কোথায় গেল? My lord, এইটা। Industrial disposition আনিসনি. You have not brought it. You have not bothered to bring it, na? Yes, sir. Yes, your lordship. Oh, yes, your lordship. Huh?
It is already both parties.
After recess, my lord. Oh, yes, yes. 2 p.m. I have another matter in your lordship's court. No, I will do both. Milord, only Milord indulgence. Milord, before Justice Gaurankar, item number 1, contempt. I will just ask for time. I will come back, my lord. I cannot handle his lordship, my lord. But only I will seek. I do not wish to deal with his lordship. I only address your lordship because the moment I stare at his lordship. At 1, quarter past 1. No, sorry, 2 p.m. Sorry. Sorry. No. I'm sorry. His lordship made me nervous.
Number 11.
Lord, this is in respect of entitlement of pension, my lord, of a temporary employee who dedicated his whole life for the government, and at the end of the life, he was absorbed in the service, and due to shortfall, he is deprived from pension. Well, on 3 occasions they have time.
When you were absorbed,
On 16/1/2009.
16/1/2009. And when you retired?
31st August 2015.
So a little over 6 years. There is a shortfall of 3.5 years
Yes,
about.
3 years, 4 months.
Yes.
Similar matter.
And similar matter, your lordship has decided, my lord, in Hirilal Ghosh, in Alochana Pan, in Gita
There was
Namaskar.
they had filed any opposition in the tribunal.
In the tribunal.
Where is your counterpart?
On last 3 occasions, my lord, they have taken time, my lord, to seek instruction from the finance department.
Finance department.
Just not today. Tell her to come. Just we are making it not today. But on Monday it will be taken up. Call the next.
Number 12.
I'm appearing for the petition. Honor. On the other day when this matter was taken up, your lordship directed to serve copies upon my learned senior. I duly served the copies of the petition, my lord.
On the last day, my lord, it has been recorded in your lordship's order that
4 respondents are not represented.
except for, but my lord, I think that out of 109, the private respondents, now my lord, whose selections are my lord, challenge hearing, I think my lord, bearing for, if I appear on behalf of 105, I think it's a sufficient representation.
No, but they are individual.
May I tell one
They
thing?
have individual rights to be
No,
affected.
they have individual right, but my lord, may I tell just 1 minute, lordship, kindly have a look. Out of 109, now my lord, the specific allegation is against 3 or 4, and they are being represented by me. But the against rest, there is no specific allegation, but the entire, since the entire selection process has been challenged with regard to the appointment of homeopathic doctors by the state health department. So, my lord, out of 237, they have chosen 109, and my lord, they have made
So
party.
this 18, 17, 93 and 104 respondents, they were also appointed.
Yes, yes, yes.
Then they
Appointed. But my lord, if they have been chosen and not.
was notice served on them.
Yes, my last milord on the last occasion.
No, he has appeared on his own.
Yes, no. The last occasion, milord, he told me that he has the instructions to appear, milord. Most of the private respondents.
Is most.
Therefore, we are saying 4 are unrepresented. Only 4.
Only 4.
18, 72, 93 and 104. You have not seen the last order. 5th August order. So whether notice, any effort was made to serve notice on them or not? Because he is appearing for all others, only 4 are remaining. And since they are also appointed, they have a valid right, a very vital right to defend.
Absolutely.
So we cannot just ignore them.
So, through mail, milord, I serve, milord, I did not
That
serve.
may be better, yes.
Through mail, I serve. And every service also filed, milord. On the
Yes, then if they don't choose not to appear, then we'll see. But we must record, the record should show that the service was effected on them, yes.
Service has been effected, milord, through mail, I have served. 1872, 94.
This is service on the lawyer who represented them, this we will not accept.
Well, I will serve again, milord. So, for 1872, 93.
Only 4 in remaining.
Through mail. Well, I serve, milord, through mail.
Affidavit of service has already been filed.
Through mail. And what if they have not opened the email, then what they will?
Specific allegation is against my lord 3 or 4, my lord.
We understand, we appreciate what you are saying, but
Yes.
since their right are to be affected.
If I may say so, milord, I have no grievance against milord 1872, 93 and 104.
Then we can proceed.
Yes, yes. I have no grievance. No grievance at all.
So if you succeed, their selection will not be cancelled.
Milord, so far as I am concerned, milord, kindly consider 2 things. So far as milord, this deputation is concerned, milord, what I have said, milord, 108 and 109. Milord, they were initially selected as milord PWD candidate. Subsequently, milord, they were final list was published, milord, by showing them as milord unreserved candidate. And milord, they milord got the mark of 73, whereas milord we got the mark milord 82.5 and 81.5. Milord, this is my first. Second point is this, milord, the person milord.
That's not correct. I shall answer them.
And so from the records.
Yes, yes, yes.
show it
I
in the
know.
records.
I know.
No, all we are asking you, if you succeed, then 18, 72, 93 and 104 will not be affected.
In my responsibility, they will not be affected.
Then my lord,
Only milord.
then my lord,
few persons will be
then my lord,
Or in that case, milord,
then my lord,
kindly permit milord.
See, you must
Let
have
him
challenged the
say-
entire selection process.
Let me
Then how
serve,
it
milord.
let,
Let me serve.
let him say that so far the challenge to the entire selection process, now he is not on that challenge to entire selection process. My lord, the prayer is that, one prayer is that challenge to entire selection process. But the another prayer is that, my lord, that let direction be given to give appointment to the petitioner in the same selection.
Already PR, I can always pay for that. Milord, your lordship will tell you.
all these things we will see what you can, we cannot do. The
Yes.
point is, if the relief touches upon the right of these 4 persons who
Then
have
we
been
suffer.
selected, then without an opportunity being given to them, we should not proceed.
Let me
We are
serve, milord.
deprecating authorities for doing this every day. We should not be doing something.
Yes. I'll serve these 4 persons, milord, and come back to your lordship. 6 and 8, milord.
কবে রাখতে চাইছেন যে কোনো দিন তো আবার নেয় না যে কোনো দিন তো নেয় না মানডে আর টিউসডে Others, yes, they are represented.
There's no question.
Get.
Number 13. My lord, I beg to appear for the petitioner.
My lord, this is a gratuity recovery matter. On the last day, I have adjourned, I begged for an adjournment for instruction, but my lord, this instruction will not satisfy you, my lord. They are far more older. It will not satisfy you, my lord. But kindly listen to me for the 5 minutes, my lord.
So you have not approached any authority?
No, my lord. There is no
How you can maintain?
5 minutes.
Only on that you tell us.
My lord, the order, the subsequent order for the recovery of my gratuity has been given to me, and this is a continuous wrong. I have still not achieved my money out of the state. Well, I am relying on this judgment only.
No. First on the maintainability, how you overcome the limitation and alternative.
I am justifying it with this order, my lord.
This is on section 20 and 21.
Yes, my lord.
What is not maintainable before the tribunal will not become maintainable before this court because tribunal is not functioning. Yes, we understand what you are saying, continuing wrong. That's not the point. We know what Tarsim Singh judgment said. We know what you are trying to say. That's not the point, whether you have availed any remedy in accordance with the act or not. That is the point. We are not on whether it is a continuing wrong or it is a stale claim. Nobody said a stale claim.
My lord, but this delay can be condoned, my lord.
Order 11. 11 plus 2000. 11th August 2000.
$160.
Where is the order of 11th August 2004? Where is the order of 11th August 2004?
11th August 2004. When August 2004 he was working.
Where is it?
My lord, I couldn't find it, my lord.
You couldn't find it. So who will find it?
My lord, it is not referred brief, my lord.
Huh?
Yes.
Is it on record? 11th August 2004 order. 11th August 2004.
11th August 2004, there is no judgment, my lord. Mm. My lord, I think it is a typographical error. Mm. 11th August,
So you are not sure of anything.
My lord, no, my lord.
You are only thinking and you are unable to find documents. And you are standing before a division bench to argue the case.
My lord, sincere apology, my lord, but this is a typographical error, my lord, I think so.
Throughout the brief. Throughout the original application and your writ petition also.
My lord, my sincere apology.
Should we record your submission that this is a typographical error? Tell us.
A sincere apology, my lord.
You can't just say anything you want here. You have to say something with responsibility. Where is it, sir? That is the impugned order. We are unable to locate. Therefore, we are, and he says it's a typographical error. First, he says I cannot find it. He has no responsibility for the brief. Which page?
Page number 130, my lord.
But would be cute. Dealing with some precious claim. It's not the way.
My lord,
Customer matter item number 62.
Yes, my lord. I was, my lord, about to place the duties of special pay carrying position in clerical gate and my clerks, clients, my lord, assignment as per this, my lord. ও নিচে আছে। আছে? Third page, my lord. বার করে দেবো? Should I find out for you, lord? Special assistant page 3, my lord. Page 79.
Anywhere in the pleading that you are a special assistant?
Yeah, I'm special assistant. And not only that, my duties are supervisory in nature, and supervisory, my lord, the term in terms of section 2S of the Industrial Disputes Act, if my salary, my lord, exceeds 10,000, then, my lord, I am excluded. Now, my lord, what is the duties assigned to me? If
Not
my
with
lord,
condition, not only
If
condition.
it exceeds 10,000,
10,000, I am not a
so
worker.
clerks get below 10,000.
My lord, that is the amendment that at last in the code. Now in the code, my lord, 2020 code, my lord, new code, it has been increased to 18,000. So, my lord, what is my duty? Special assistant will be accountable and responsible for running the department. Section under them and their duties will involve looking after and checking the work of other clerk or clerks, sub-staff, and instrument up to rupees such and such, clear transfer checks, vouchers up to including such and such, passing will include verification on signatures or scrutiny as to the correctness of endorsement. There shall be signature, passing of authentication entries, and for verifying authenticate vouchers in the computer, etc. Accept, verifies cash transfer, checks, other instrument. Then signing voucher, checking all voucher, advice statements, things are. But the sentence start with, my lord, running the section under. I categorically said, my lord, yes. Okay. I'm sorry, the Industrial Disputes Act এখানে আছে? Disputes Act? এই আছে। Millard, Industrial Disputes Act. The 2S. May I read for my lords? Workman means any person, including employed in the industry, to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work, hire or reward, whether the terms of employment expressed or implied for the purposes of to industrial disputes, including action with or as convict of that dispute or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include any such person, one who is subject to the workforce of not applicable. Exercise either of duties attached to the office or by reason managerial nature. So I'm covered by this Roman 3.4. So, my lord, any contract or award enforceable in law as per, my lord, his understanding, I expect, my lord, that, my lord, if it, my lord, the definition says, my lord, that supervisory.
So we should declare you to be a managerial staff.
My lord, that is, my lord, 79 clear mandate. Now the definition of managerial clerk, now I will show your lordships two judgments, one of your lordships court, another is Supreme Court, your lordships court division bench, that it is not about the nomenclature but the function. I will, my lord, 70 Supreme Court, Anandabazar Putrika, my lord, a famous Bengali, my lord, Delhi, vernacular, my lord, there was a question, my lord. And, my lord, this question, my lord, was answered.
Never arose for consideration here. So
here,
there can be no determination.
No,
unless it is an issue made out and decided after giving opportunity to the parties, merely because you say so, can we declare that
correct,
you are a
no,
managerial?
my lord, here, my lord, the court, the argument was made.
Where you have stated in your writ petition that you are resorting to this proceeding because you are a managerial staff or you are a
I have
supervisor.
said in my reply.
Therefore,
in the
there is no
reply,
scope.
Miller, today, Miller, I could not anticipate your lordship's mind. That is my failure. Had it been, Miller, dropped in my mind, I would have, Miller, we would have been armed with, Miller, 65 Supreme Court, which says I can make out a new case in reply. That is, Miller, my entitlement subject to correction. Supreme Court has given me the liberty. Now, Miller, if first of all, if the statute says, Miller, the definition of workman, I am covered by Roman 3.4 and my salary and the 79 accompanying, my lord, my nature of job, 70 Supreme Court, my lord, subject to correction, my lord, Anandabazar Putrika, 70 volume 3.
Before you embark on such elaborate submissions, can we declare you to be a managerial staff in these collateral proceedings for a different purpose altogether?
No, today, Miller, he questions the maintainability of a writ petition.
Correct. So that's the issue. You are embarking on a totally different tangent, saying that I am a managerial staff.
No, I said, Miller,
I am in a
that he has to show. That is why, Miller, his statement must be
holding a post which is covered by the Shastri Award.
I am holding.
There is no dispute on that.
Correct.
So now, in view of this admitted position, does this argument lie in your mouth?
Yes.
Does this argument lie in your
Yes, I will show a judgment which says, Millard, why? Shastri Award, Millard, cannot be, Millard, read as a statute, number one. Shastri Award, Millard, gains his strength.
So that is a different thing altogether. You are embarking on a tangent to try to show that you are a supervisory and managerial capacity.
Because, Millard,
that cannot be done in the present proceeding.
Today, Millard,
whether Shastri Award, if you are covered by that, that comes in the way of discharge of exercise of discretionary jurisdiction. It will operate as an absolute bar. Those are things that arise.
Yes, Millard, absolute bar, Millard, I will show, Millard, that my right
This is not an issue which we can decide here, whether you are a manager.
He raised this question, I did not raise.
No, he's not raising this. He raised a different issue.
He said
He raised an issue.
tribunal.
He raised an issue which there is no dispute. You are covered by the award. Now, still, if you are covered, can you invoke a jurisdiction?
Yes.
It's so in that circumstances. That is only you are going on a different.
I am saying, Millard, that Shastri Award, even if it covers me, then, Millard, I have to come to your lordship may kindly, Millard, have the charity to consider whether, Millard, the Shastri Award can be read and understood, Millard, without, Millard, looking into, Millard, the definition of the Industrial Disputes Act. Because this Shastri Award had taken note, if I read for my lords, that, Millard, kindly sees the code 1617, the issue of non-maintainability, if your lordships kindly take pain to turn page to 57, which will disturb my lord's mind as to whether this issue was considered. The issue of non-maintainability of the petition has been raised in the final stage of hearing. However, the report such plea was raised at earliest possible opportunity at the stage of admission of the writ petition. It suffices to note that the High Court decision not to on the ground of availability of an efficacious alternative remedy is a self-imposed limitation. The essential rule of policy, convenience, and judicial discretion. Possibly your lordship was harping on that, rather than a rule of law, restriction and jurisdiction. There is some which your lordship possibly correctly understood the mind of the honorable judges, Millard. Possibly these lines, Millard, mean satisfied. There is no absolute in such cases. Whether or not the external jurisdiction of Article 26 is to be circumstances. Established principle of law, notwithstanding the existence of is still entertained, particularly in enforcement department it's a violation of the principle of naturalist or a person is a challenge to the violence of the statute. It's absurd to refer to R. Redappa, 1993. Oh, sorry. Millard, these judgment, Millard, possibly may lend, Millard, meaningful assistance, Millard, 1993, 4 SCC, page 269, paragraph 12 to 15. 259. কোথায় গেল কত গেল কত গেল কোথায় গেল 12 কোথায় 12 প্যারাগ্রাফ 4 5 আর এটা 4 5 paragraph 5 Millard. More than a decade has gone by since these employees were dismissed by participating in strike called union such and such, but end has not reached. Barring appellate and divisional, I start from Millard the line. The jurisdiction to exercise the power under rules such and such was dependent on the existence of this primary fact. If there is to the jurisdiction exercised by the High Court under Article 226 or the tribunal is not as wide as it is an application. But once the court is satisfied of justice or arbitrariness, then the restriction, self-imposed or statutory, stands in and no technicality on exercise of power can stand in way of rendering justice. By submission of the Additional Solicitor General that the CAT Hyderabad exceeded jurisdiction according to the finding, there was the material in support of the finding, but it was not reasonable or practical inquiry. The jurisdiction to exercise the question then and legality because it has been informed in imperial revision unless the higher authority is found to implement its mind to basic infirmities in the order. Mere repetition instead of adding strength to the order renders it weaker and more vulnerable as a higher authority constituted under the Act or the rules for proposal shall be deemed to have failed in discharge of his hereditary obligation. Millard, this judgment, Millard, number one. Number two, whether I'm correct in making this submission, Millard, initially there was a view of your lordships, Millard, when in terms of the Administrative Tribunals Act 85, read with Millard Article 323, 323AB, and Millard as well as L. Chandrakumar, you have to approach first tribunal.
This does not arise here. This is not arising out of tribunal's order.
No. Here, Millard, the
This
question is
size of jurisdiction under 226. What are you
it is an
doing?
alternative bar, Millard,
Relying
alternative
on a
remedies of the
judgment
bar.
where the tribunal's jurisdiction is
Millard,
being
alternative, Millard, first of all, the Shastri Award covers me. If that is the Shastri Award, Millard, question here is, Millard, Shastri Award cannot bypass or overpower, Millard, the mandate of the Industrial Tribunal Act. Was a reference, Millard, in the context of Industrial Tribunal Act. I may be placed, Millard, as an employee, assistant, special assistant, and my duty has been assigned. That is why Supreme Court said.
Who is neither raised nor decided.
No, Millard, kindly sees that
We will
Supreme
not
Court.
go on that issue.
That,
We
yes,
will
that
not
issue.
go on that issue.
Yes. I'm reading.
We will not go on that issue.
Millard,
Whether
kindly
you are
see.
a managerial staff.
Kindly,
or not.
Millard, no, Millard, possibly it was not placed. Mr. Paragraph 19, Mr. Palchodi contemptuous alternative remedy before the Industrial Tribunal, admittedly actually joined the bank as a clerk and was subsequent of a special assistant. Mr. Bose submitted to the petition was drawing a excess of 40,000 per month. The court had addressed this issue.
That is the basis for the court to exercise jurisdiction in your favor. That is your submission.
Kindly says, I was not, I did not complete. He has questioned the charge sheet on the order. As per the definition of the workman, under section 2 is the Industrial Disputes Act and attached to the notice drawing orders, exceeding such and such does not fall into the content. such and so and such. For the contention as in such a regarding on the ground of alternative lacks such stand overruled.
That's your submission.
No, court said kindly Millard has no. Millard possibly Millard I am unable to Millard communicate. Kindly Millard read again. If your lordship kindly Millard, it's 258 Millard. With humility Millard kindly says. Issue number 1 decided. Kindly says Millard. Possibly I am right Millard in understanding this paragraph subject to correction.
258 paragraph
19. May I read or your lordship? May I read?
Just a minute.
Mr. Palchodhi concluded that the petitioner had an efficacious alternative before the state tribunal. Petitioner initially joined the bank as a clerk and was subsequently special assistant. Such and such submitted that the petition was drawing of 14,000 per month, 40,000, and Section 2A of the ID Act 1947 and office and drawing wages exceeding 10,000 from the ambit of workman. In view of the position, the special assistant and the salary drawn, it does not fall within the complementary on Section 2A of the Act. Accordingly, for the reasons stated in the section, advanced by Mr. Chaudhary, the ground that such stands overruled. If I'm not a worker of the Act, Millard, the question of
yes,
I have to be a workman first. There is elementary. And Shastri Act cannot overpower Millard the intention of the legislature, even if Millard evil consequences flow from the statute. Now, Millard, this submission, now, Millard, the Honorable Supreme Court on this code, Millard, Anand Bajar. বার কর তাড়াতাড়ি এখান থেকে বার কর না আই এম সরি মিলাড আই এম টেকিং 1970 volume 3 SCC page 248 paragraph
addressing issue number 3.
Supervisory cabinet.
What is this?
Yes, but this is not the only the form or the substance. Not substance, but the form, the nomenclature. That is Millard paragraph 3. It is Millard the even if it is a supervisory, but I am not a but I actually am functioning as a clerk. Running the department, the language is now, Millard, the division bench, Honorable Division Bench of your Lordship's Court, Millard Coordinate Bench, placing reliance on this judgment, Millard 70, volume 3, had passed the same order, Millard, way back in Millard 1989. This is reported in Millard 1989 SCC online, Calcutta 311. Division bench, Millard, your Lordship need not take trouble, but this relies on Millard, the same judgment of the Supreme Court, and takes a similar view. But I will not burden your Lordships with the series of judgments on the same point. The next judgment, Millard, which I wish to rely on, Millard, he said delay.
Which paragraph of this 93?
70 Millard, volume for paragraph 3.
93 for SCC.
Paragraph 5.
5 perhaps you said, yes.
5, yes. Now, Millard, this judgment, এটা কোথায় গেল? Millard, this is the judgment my learned esteemed friend Millard has questioned Millard. Millard, your lordship knows Millard that he has insisted on a term Millard. The prejudice is likely to cause bank Millard, they likely to cause. My gratuity was withheld. The gratuity court has come to a finding while releasing Millard the amount that the bank did not Millard suffer any loss. And Millard, the delay point, I got this Millard, this delay point 2013 volume 1 SCC page 353, 2013 volume 1 SCC page 353 Millard
96 CWN 8274.
For the same Millard, the proposition of law endorsing the view taken by the Honorable Supreme Court 1970 volume 3 SCC Millard page 248. Paragraph 3 has been relied on by your lordship's coordinate bench. The bench Millard had taken the subscribe to the same views. No, the endorsed, sorry, followed. Bound by the Supreme Court, Millard. Today, Millard, I'm sorry, Millard, the choice of word is absolutely wrong. I stand corrected. Millard, Millard, that is Supreme Court, yes. Now, Millard, the delay point, that is 2013 1 SCC page 353, paragraph 12. The state, especially a welfare state which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the Constitution. Our Constitution is an organic and flexible one. Delay and latches is adopted as a mode of discretion to decline exercise of jurisdiction to grant relief. There is another facet. The court is required to exercise judicial discretion. The discretion is dependent on facts and circumstances of the case. Delay and latches is one of the facets to deny exercise of discretion. It is not an absolute impediment. There can be mitigating factors, continuity cause of action, that apart the whole thing shocks the judicial conscience, the court to exercise discretion more so when third-party interest, no third-party interest is involved. Thus, analyze the petition is not held by the doctrine of latches. The same is not a constitutional limitation. The cause of action is continuous, and further, the situation certainly shocks the judicial conscience. The question of constitution of delay is one discretion and has to be decided on the basis of facts of the case at hand. At the same vary from case to case. It will depend on that what the bench, a breach of fundamental right and the namely claimed, or when, how the delay arose. It is not that there is any limitation for the courts to exercise their power under Article 26, nor is it that there can never be a case that the courts cannot interfere in a matter after the passage of a certain length of time. There may be a case where the demand for justice is so compelling that the High Court would be inclined to interfere in spite of delay. Ultimately, it would be a matter within the discretion of the court, and such discretion must be exercised fairly and justly as to promote justice and not to defeat it. The validity of parties' defense must be tried upon principle substantially equitable. No hard and fast rule can be laid down as to when the High Court should refuse to exercise its jurisdiction in favor of the party who moves it after considerable delay and is otherwise guilty of laches. Discretion must be exercised judiciously and reasonably. In that event, the claim made by the applicant is legally sustainable. Delay should be condoned. In other words, what circumstances justifying the conduct exists, the illegality which is manifest cannot be sustained on the ground of laches. When substantial justice and technical consideration are pitted against each other, the cause of substantial justice deserve to be preferred, for the other side cannot claim have a vested right in injustice being done. The opposition, the point of delay was never taken. Millard, page 123, annexure P14, the point of delay was waived. In the opposition filed by the bank had a right, Millard, to take this point. Bank, Millard, has chosen not to do it. So, Millard, this is a personal right assigned to the bank. Bank had consciously, Millard, relinquished its known right. Bank never argued it. Yes, Millard. The court said, and this point was never urged. Millard, today, Millard. Yes. delay was not taken, my lord. The point of delay, my lord. Otherwise, my lord, I could have a chance to explain. I could get a chance to explain, my lord. Delay is a, my lord, factual matrix. Why the delay?
Mr. Vasu, please come to page 215 of the paper book.
Yes, my lord. The scope of judicial review.
Paragraph 15.
In the present case, the court is called upon to determine whether writ petition is maintainable in view of the existing alternative remedy,
Issue number 2.
whether it is liable to on the ground of delay, whether the court has taken the query in affidavit.
This is the issue framed.
You have argued successfully before it was not.
The issue framed. Unless the points are there. Law pleading says that they have raised some points. If they are
Based on Miller, subject to correction. Yes.
pleadings.
Pleadings were,
Issues are being framed.
yes.
And when you consider the decision on this issue, page 217. There is
The issue of delay was raised by the in the affidavit opposition stated there is no prescribed time limit for filing a writ petition. Now, Miller, affidavit opposition kindly says.
that is why I am saying that they are not foregoing the right to raise this objection. They raised that was turned down.
That was raised, considered.
Turned down. That can be said.
Yes, I said, Miller, in the affidavit, my specific contention, it was not raised in the affidavit.
But if you say it,
Yes, Miller, kindly sees the affidavit. I may be wrong. I sometimes, Miller, by reason of my Miller unwanted exuberance, I miss certain points, Miller. But
issue decided wrongly.
decided wrong.
Issues decided wrongly. What will be the
No, Miller, issues decided, Miller, the court, Miller, points argued.
decision is in your favor?
Yes.
But these issues decided against you.
This issue, Miller.
According to the findings reached.
No.
The delay.
I'm not saying so. Miller, I do not wish to be trapped, Milord, in your lordships. This is a kind of a deal, Milord. I cannot know. I am not going into that question answer, Milord. But court said the delay. I understood, Milord. I won't be trapped. I know. It comes from a Milord, from a civil lawyer. Although Milord in Bengali we said that जो सन्यास है उसको जो पूर्वाश्रम है उसको याद मत दिलाइए इन बंगाली सन्यासी के कखनो पूर्वाश्रम देखाते नहीं so I don't want that your lordship, Milord, it's a kind of reminiscence, Milord, but today what I say, Milord, that this point was never taken in pleading. Court they argued because the lawyer, Milord, who argued this matter, unfortunately, Milord, he is not with us, Milord. He has raised this point. Question here is, Milord, the court had applied its point.
That is,
No, I am not going to that.
I'm only that issue.
Yes, that is true.
Point of law, my lord, there is no estoppel.
No, it is recorded that in this affidavit in opposition, the delay point was raised by them.
Milord, delay, like a limitation, it's a mis. No, I am not going to that. He said, yes, yes. I'm extremely good.
And how much delay is there?
5 years.
5 years from the revisional order?
Yes.
Appellate court, no,
Appellate court's order is 2013, they have challenged it in the year 2018.
That is the point of reference is 17, Milord, I got, Milord, the gratuity. Why I tell your lordship? Milord, my learned esteemed friend always said that.
And there was a offshoot of criminal trial also.
I was not entangled, but Taposh was entangled. Taposh ultimately, Milord, I had to file a writ petition for the RTI, Milord. I filed a RTI. They did not respond. I filed a writ petition for getting the answer.
For what? For answer to what?
Answer to what? RTI.
What is it you wanted to know in the RTI, under the RTI?
Taposh Banerjee's final order, which is at page 182 of your lordship's brief.
Oh, yes, you have stated that you are pursuing the matter before the gratuity court. Yes,
There is gratuity.
somewhere we have seen that. Yes.
I was pursuing the matter. Gratuity, Milord, he said, bank did not suffer any loss. That is why gratuity court said, I bank to prefer any appeal. Accepted, Milord, the fact.
So if
Section-
bank did not suffer any loss, then Tapas should also
no.
be exonerated.
Taposh Milord, again Milord, I will be trapped. Taposh, again, litigation is also a game of chess sometimes. I'm not going there. Then yes, I don't think his lordship does not want to know this. His lordship. So, Milord, I need not trouble your lordship, Milord, by reading, Milord, paragraph 12 to 15. 12 to 14 I have read. Milord, delay has been answered. And Milord, question today, Milord. Yes. This, yes, 12 to 15.
There are recent judgments. Right.
Milord,
Basu, you are aging now.
2025.
Why not change?
Yes. Now, Milord, so Milord, if I have correctly understood my learned friend's submission, first of all, Milord, that yes, yes.
Some delay, but no latches.
No latches, Milord. Negligence cannot be attributed to me. It is not attributable.
Nomenclature of my post is relevant, the profile of the view, plus no absolute bar under 26.
Yes. Yes.
Molecule of natural justice.
Yes. And Milord, the basic structure doctrine, Milord, my right to approach, Milord, under a judicial review is a basic structure doctrine. And I have come before your lordships, Milord, because it is also, Milord, my fundamental right, not to, Milord, in service, but, Milord, my right to livelihood that has been taken away. And, Milord, the disciplinary authority, Milord, the reasoning, arbitrariness, Milord, Article 14. Milord, your lordships, Milord, at the cost of tiring reputation, since your lordships have given enough indulgence to the bar many a times. Milord, the conclusion and reasoning, Milord, there is no friendship. So this is most unfortunate part. Disciplinary authority mechanically, Milord, followed, Milord, the disciplinary authorities, inquiry officer's report, passed an order of award punishment. Appellate authority involved, just recorded, Milord, passed. So, Milord, whether this is, Milord, can be a violation of, Milord, the article?
You are not raising any issue regarding a lesser punishment.
No. I said, Milord, the
Yes,
punishment.
yes, for your lordship.
No.
Yes, there are two.
No, I said, no,
Yes.
your lordship, but Milord, he is finding strength. Milord, I tell your lordship, Milord, your lordship, since he said that I was only confined to, Milord, I showed your lordship specifically wanted me to show the reply which I have given in the charge sheet. That is, Milord, very precise, Milord, answer. Brevity is the soul of it. Your lordship said, what is the reply? You show me, not reply, because sometimes you people become wise. Brevity in argument. That is, that I did not inculcate that virtue, Milord. I will try, Milord. Milord, since your lordship has asked me, Milord, that what is the stand taken in the reply? Shown, Milord, 62. There is no point. Yes, authority. There are two aspects, show cause. You come, attend the hearing, I went there and I made my submission. I said that was absolutely, I was victimized. Milord, victimization, Milord, is also a ground in service jurisprudence, because, Milord, I am, Milord, only saying that page 182. I couldn't understand.
Have made a mistake before the disciplinary authority.
Yes, whether, Milord.
Pardon is the word you have used.
Yes, pardon. Milord, for the mistake, Milord, suppose, Milord.
There is no occasion to say victimization.
Yes, no, victimization, Milord, I said, Milord, in the earlier paragraph, I said victimization. Milord, kindly sees what is, Milord. Yes. So I have seen also. Milord, every failure is not sin. Every failure, my lord, suppose I committed a mistake. This cannot lead to the path of admission. Number one. Now, my lord, he, my lord, kindly sees that there must be, in order to prove a misconduct, my lord, there must be a disciplinary angle. The bank, my lord, had tried. I had to face an ordeal, but bank was very much conscious. And my lord, bank, that is why, my lord, I was not entangled with a criminal case. Only Taposh was entangled. Because bank made a very conscious choice. My lord, knowledge is communicable, wisdom is not, which your lordship has taught us many a times. So, my lord, bank had a knowledge, but in its wisdom, my lord, bank, my lord, said that no, this Mr. Bosch's client should not be entangled with a criminal case. That is wisdom, my lord, which was not communicable. But today, my lord, the lawyer, by reason of his own, my lord, alacrity, tried to make out a new case, my lord. But I respect his effort. But kindly see the plight, 33 years in an institution. I have served. There is no element, my lord, no blemish record. Retired. My lord, the other day, 1 month prior to my retirement, charge sheet was served. I joined 81. Disciplinary conclusion, my lord, it was concluded in 2013. 32 years more than. Yes, my lord. Because the questions, my lord, which he raised, my lord, first of all, maintainability delay, and my lord, and he said the judicial review principle. Question is, my lord, this is one part of the story. The other part of the story, my lord, the Article 14, that is, my lord, the irrationality or the decision-making process, he cannot confine, my lord, the wisdom of a court by saying, my lord, that court cannot. My lord, if whether I am correct in understanding, my lord, the constitutional scheme of Article 226, my lord, it is much wider than Article 32. My lord, if that is so, my lord, any legal right means, my lord, that my lord is my right that not to be treated unjustly, my lord. If the fairness is one of the components of a justice delivery system, then my lord, I was unfairly treated. Where is the transparency? I put this question to myself.
How you sustain the finding of the inquiry officer? That is all. There is a very small order. The inquiry officer's report. There are only 2 paragraphs which you are required to see. He says, this is my assessment. Then he says, I am of the view that the so-and-so should have taken minimum caution at the time of verifying the above data, which he did not. And he verified the same. However, all the evidences and depositions on record do not suggest any malified intention on the part of the CSE, and the mistake so committed in all likeliness is unintentional. There is no denying. Who has to deny? There is no denying the fact that
verified in a routine manner. Mechanically, well, in a routine manner means mechanically the standard which should be maintained by the concerned employee, he did not maintain the same. In a slip-shotted manner, he has done the work.
What does routine mean? Routine manner?
Means mechanically, my lord. Mechanically.
Routine manner means mechanically. Mechanically means with non-application of mind. Routine means what is being done every day. It is on a set pattern. So routine may also be read as norms.
Yes, my lord.
Unspelled norms, unspecified norms.
He also stated in his petition, also I'll show your lordship, that he has done in good faith, but he perhaps...
Don't forget about what he said. We are not on that. We are on what the inquiry officer found. He found the same thing. He says the record does not suggest any malified intention and in all likeliness is unintentional. This is his finding. Then he says, I'm inclined to treat the allegation as proved. How such a finding can be sustained and how the disciplinary authority accepted this finding? If at all he should have differed with this, that how you are saying it is without any intention.
That means, my lord, the alertness which is expected is not at all there at the relevant point of time.
Yes. Disciplinary authority could have said that why you have not given a finding regarding the intention. This material is on record, you re-examine, or based on this material on record, I find that intention and malified intention and whatever it is, unfairness is there, or if there is a deliberate commission of any kind, he could have recorded with reference to the material, but he's not. So this finding, even if it is accepted, then how it can be held that charges are proved? Doesn't appear to be a plausible view from a plain reading of the inquiry report. And what are the charges? Articles of charges?
Because of charges is
Page 60. 60. Same as allegation number 2 is the push minute, page 182.
allegation is doing any act prejudicial to the interest of the bank or gross negligence or negligence involving.
No, the allegation is above that. This is what the allegation constitutes.
Yes, our current account number such and such in the name of Global Construction was introduced by Sri Taposh Banerjee using his customer ID number such and such on 25th September 2012. This introduction was modified in the system on 9 January 2013 using customer ID number such and such, which is of AS Construction. You had verified the same. Due to this modification, the fact that account opening form does not contain the signature of branch head, the account opening form was replaced with a fresh one at a later stage. Thus, the original account opening form was removed, bearing introduction of account of Sri Taposh Banerjee and signature of branch head, and substituted it another account opening from bearing introduction by AS Construction without signature of branch head. The allegation constitutes gross misconduct on your part as under doing any act prejudicial to the interest of bank or gross negligence or negligence involving or likely to involve the bank in serious loss or in terms of clause 5J of the memorandum of settlement on disciplinary action procedure for
And when did you communicate the list of documents or the witnesses?
The witness আর এগুলো সব draw হয়েছিল document.
Who has proved the charge? Whose statement, which document proved the charge?
One eighty four.
PO submission on allegation, charge sheeted employees submission on allegation, and EO's assessment. No document, no witness, no argument on this point.
I'll try and come to 184. Accordingly, the undersigned proposed punishment of dismissal without notice to Taposh Banerjee and same was conveyed to him under cover. এটা কার বলছেন? তাপস ব্যানার্জি দেখাবেন কেন? ওটা জিজ্ঞেস করছেন জজ।
Your charge memo itself does not contain any document list. It does not contain any name of witnesses. So can it be established like this?
Well, at the relevant point of time.
I say you have done this. I say I have not done it. You have done it.
At the relevant point of time, it was not mandatory that you should annex the. Subsequently, in the year 2020, that clause has been amended by the bank and added that at the time of issuing charge sheet, my lord, the list of witness and list of documents should be annexed with the charge sheet. Previously, it was not mandatory. But after 2020, it was mandatory. Toru Dottor oitate ache.
Shastri Award, my lord, if he relies on that, my lord, the procedure has been let down. And he says, my lord, I am taken by surprise every time, my lord. And how could law be changed? In 64, Supreme Court said it is the duty of the employer to, my lord, to speak about the, my lord, the contour of the disciplinary proceedings. Surinamal's case. You must.
No, you have to bring home the charge with reference to some material. Findings are to be founded on some material. There is no material.
ওর সঙ্গে চার্জশিটের জজ সাহেবের কোশ্চেন কিছু বুঝতে বলছে এই চার্জশিটের সঙ্গে উইটনেস আর ডকুমেন্টস কোথায় পাঠিয়েছে কিছু না জেনে উল্টো পাল্টা বলছে।
So that is not there. Then the law did not require as per your submission.
But my lord, in 2020, my lord, that has been amended by the UCO Bank's rule and
till 2019, one was required to serve a charge memo and then say, are you guilty? And if he said no, then he was to decide whether he is guilty or not guilty.
But subsequently, it was, my lord, during course of inquiry, it was supplied to them.
And the single judge has directed what relief he has granted.
Yes, set aside charge sheet, the inquiry report, as well as, my lord, the decision of the disciplinary authority and appellate authority.
Very well. You are relying on which judgment? P. Gunasekar.
Yes, my lord, and another, my lord, so for the review, how far the writ court can review.
That's why we are saying P. Gunasekar.
So already on the last occasion, my lord, I have given the judgment.
2015 2 SCC page 610.
In addition to that, my lord, one unreported judgment also given.
That is P. Gunasekaran.
And another judgment, my lord, also.
Your lordships are referring to a different judgment of 2015 Supreme Court, volume 2 SCC.
It was the latest
That was the, my lord, your lordship says do's and don'ts, my lord.
That is, he has given that judgment.
No, we have the supply.
And also another judgment.
We have given.
Oh.
Your lordships wanted us to give. It has given paragraph 12 and 13. These are the two relevant paragraphs.
CBW number 2148 of 2015.
Yes.
This is narration.
Yes, you are relying on this. Which paragraph? This is 3 judge bench. So it is on that limits of judicial limit.
Yes, sir, judicial limit. And so far my lord, the contention of the workman is concerned, but mere the ceiling of the income does not decide who is a workman or not.
No, he has shown the work profile running the department around that.
Whether my question is, I am asking myself,
No, whether that document is sufficient to say that he is on a supervisory post or not.
Whether he can issue any charge sheet against his subordinate,
not
whether he can my lord, grant leave to his subordinate, whether my lord, whether he is involved in the recruitment process or not, nothing has been spelled out.
I'm the employer.
That is not a test.
I respect his poetic imagination, but not in this case.
Take down. We will record your
Or you can write it over here also.
কত 3 তারিখ ছিল তো?
Thursday.
ও নিয়ে নিচ্ছে।